Good morning, Mr. Howarth.
Good morning. Thank you, Your Honor. Please the court, Don Howarth and Suzelle Smith for Life Care Centers of America. The question put before the court this morning is whether to accept the invitation of the Commonwealth to, for the first time, criminalize negligence, and in the process...
I don't think that's how the Commonwealth would put the question.
No, I meant to put it neutrally, Your Honor. I don't think they would, but that is, in fact, what's at stake here. And they would ask you to do that along the way, overruling Podesta, Wolanski, beneficial finance, all of these cornerstone cases, not just in Massachusetts, but in the criminal law generally. The beneficial finance case...
Couldn't we get where the Commonwealth wants us to get just by applying regular principles? I mean, do we need to adopt a whole new theory? Couldn't we just apply traditional principles and see if that makes out a manslaughter case?
That's correct. You could.
So we could get there without a new aggregation theory.
Well, it depends where they want to get. If they want the new aggregation theory, you can't do it by applying traditional principles, because beneficial finance and the other cases set the standard that a corporation, which is a fiction, has no intent of its own. The criminal acts, the criminal state of mind, have to be that of a person that is then flowing upward to the corporation. So we agree with the Commonwealth that actions and that knowledge and that intent can in fact flow upward to the corporation. But the crux of it is that the bundling of that has to occur at the individual level, where there is some mind that can actually make a choice whether or not to alter its actions.
You don't disagree that I don't think you do, that you can aggregate to get to knowledge, right?
You don't need to aggregate to get to knowledge. All of the knowledge flows upward. We don't deny that at all.
But you may have to add people together to get to knowledge of the corporation.
The corporation has the knowledge of all of its people together. It has the intent of all of its people together. It has the actions of all of the people together. But it's when the bundling of those things takes place in this cafeteria style that the Commonwealth is asking for some knowledge here, some actions over there.
Well, but I mean, isn't there a big distinction? But I mean, I thought that your point was really about intent. I mean, just take the Bank of New England case.
Yes.
Now that's you have different people knowing different things about the $10,000 regulatory requirement, and the court says that's okay. You can aggregate those, and the corporation has knowledge. You're not disagreeing with that.
Not at all. In fact, that's exactly what Bank of New England was about when the statute that required...
Your disagreement is about the intent part.
Yes, when the statute required only knowledge in Bank of New England, the court there said that flowed up. It was on the second part, that is to say, where it required knowledge and a specific intent, a culpable state of mind.
I know you say there was somebody, but it seemed to me that the court there was saying that flagrant disregard in that instance could make out intent.
Yes, we are not saying that the court shouldn't use and that the Commonwealth can't promote every inference and circumstantial evidence. But what it has to be directed to under the law is that there was an individual or more than one individual acting who could be said to have that culpable state of mind. If you don't, then it all becomes a fiction. It becomes a second fiction. If you can allow the picking and choosing and putting together up here at this ethereal sort of imaginary friend of a corporation.
Well, since corporations can now speak like individuals, maybe they can intend like
That's right. Yeah, but that's correct, Your Honor. But when the result is driven, when you create a fiction and the fiction then creates the crime, as here, because it's the knowledge combined with some other intent, where that person who had the knowledge didn't act, and the person who acted didn't have the knowledge. That's what they're asking you. So it's like the bad joke about the economist and the well who say, well, we know how to get out. The first thing we'll do is assume we have a stepladder. And it's the assumption, it's the fiction that they want that drives the whole process.
Go ahead.
This is just a factual question. Has the Commonwealth, there were 2 counts here, right? One was based on the nurse, is it Edwards?
There are 2 counts here, but it doesn't distinguish with Nurse Gail Edwards. The first count is the manslaughter, which is what I'm talking about now, and there's a second account for abuse and neglect. And they urge this doctrine of collective or aggregate intent as to both accounts as an alternative to the traditional respondeat superior, which is not being addressed in this report up.
But for these purposes, we're putting Nurse Edwards to one side.
That's correct, because the report is only as to the collective intent. And it's that intent that would then break down this tradition between having a culpable state of mind, intentional action in an individual as a basis for a crime,
Yes.
and combining innocent or negligent acts, which does exactly what they don't want to call it. It criminalizes negligence.
Mr. House, let me go back to Justice Cowan's question. If we were to conclude, under the sort of Wolanski line of cases, that there was a flagrant disregard here, if not by the original nurse who removed the WanderGuard bracelet, but by the nurses, who checked the treatment sheets, didn't pick it up, and or people who saw this patient and should have seen that she didn't have a WanderGuard bracelet on, would that satisfy your? I'm not saying that happened in this case. You may say that there's insufficient to find the Wolanski standard, but assuming that we did, then your concerns would be satisfied, correct?
That's correct. We embrace the Wolanski standard that if any individual or more than one individual acted with that flagrant state of mind, however that is proved about the individual, but the focus has to be on the proof of the individual, that would be sufficient for a crime. And that isn't actually, it's not a matter of whether the evidence is sufficient. We say it's not, but it isn't even before the court this morning. What's reported up is this issue of collecting intent. And it's that one that we say blurs the line and the important distinction between that which is intentional and that which is negligent. Or as Benjamin Franklin put it many, many years ago, even a dog knows the difference between being stepped and being kicked. And that's the distinction that we're talking about here, the distinction in the law of the intent, the culpable state of mind where an individual actor makes that choice and either goes ahead and stops or goes ahead with the conduct. And if we're arguing about that by circumstantial evidence or any other way, then the Commonwealth has everything that it needs. But if we go beyond that and say it can pick and choose, a little knowledge here, a little action there, and I have this intent created in some fictional mind, then we open the door to something that is nowhere existing in the law, not in the civil law, Berbiglia, here in Massachusetts, not in the First Circuit law, in the Bank of New England case, where whenever that intent finding has to be made, you look to an individual and then reflect it up. And that's why Beneficial did more simply than say it has to be an individual in finding.
Are there no jurisdictions in which collective intent is accepted?
There is no jurisdiction in which collective intent is accepted. In all of the cases that we have cited, and in all of the cases that have been cited in the briefs by the amicus filings, by the Commonwealth, there is nothing where the court allows this mixing and matching of the actions and thoughts and intents of different actors in order to get a collective intent.
I take it that Beneficial was a conspiracy case, so conspiracy is a little, it pushes it more towards the collective, right? Because
Well,
you
it
have
does-
to,
it
you
does
have to
if you
find
look-
that somebody's part of a conspiracy, right? And then you get much more of a collective piece of it.
You do in that sense. And the law has definitions and has dealt at length with that issue of where you have a conspiracy, and then that conspiracy itself can be projected up to the corporation. But it is, again, not a question of simply finding knowledge and conduct which we draw up and put together in a way they don't exist in the real world, and then suddenly we have a conspiracy or intent. I'm not supposed to touch that, I'm sorry. Conspiracy or intent in the corporation that didn't exist anywhere else. We do have that new brooding omnipresence of a fictional corporate mind that every corporation then would have to deal with. So it's under all of the cases, and at page 26 and 27 of our brief, we give a kind of a survey of them, SABA, LBS, and so forth. There is no intent through aggregation anywhere for exactly these reasons. And as the judge below put it, not only would this criminalize conduct which was not criminal otherwise, negligent or even innocent conduct, but it would also make respondeat superior completely superfluous. You wouldn't need the instruction or the notion of reflecting up the conduct even of a low-level employee, which we have here, because you could pick and choose between employees of the corporation in order one had the knowledge, the other knew of the risk. That one didn't act. This one who didn't know of the risk did act. Now becomes an intent through this corporate fiction, where the fiction then drives the process. So that's the evil to be avoided here, and we've cited that, the cases, and also we and some of the briefs filed in support, the work of Professor Leap and others that in the mechanism through, I regret to say, the imperfectibility of human beings, that you're always going to have errors in these highly vulnerable patient and healthcare situations, and that over-deterrence is actually a negative here. I think that ran throughout a number of the briefs. I thought Mr. Harshbarger's brief was especially helpful in that regard. There was, I saw the amicus brief of our friends at the, I attend some of their meetings at my age, but my friends at the AARP, who really are dealing with a problem we don't have here in Massachusetts. They're dealing with that Missouri case where they don't reflect up the intent of the lower level employees. That's the issue there. Massachusetts has had that since beneficial finance, and they believe that apparently that it's really the devil that's running the nursing homes, and I guess I would then stand with Sir Thomas More and say, let's give the devil the benefit of the law for our own safety's sake, if that's the
Mr. Howarth,
case.
let me ask you, as you know, and I'm sure I can anticipate your answer, but the Attorney General, keeps saying, and of course I understand, that they're not looking for prosecution for, quote, mere negligence, but for, when you have, in the Attorney General's words, collective recklessness, and is that sufficient to sustain a manslaughter conviction?
Yes, if that means more than one act of recklessness by an individual, they don't even need collective recklessness. One is enough. If they mean that which is not reckless.
Well, as you know, they say, is it reasonable to infer that some one or more individual employees must have acted with the requisite? I mean, that's how they attempt to deal with it.
That's not a problem at all. We don't resist that. That's circumstantial evidence and inference. They can try this case by asking the jury to find that it's reasonable to infer, based on the evidence, that some individual employee acted recklessly with his intent substitute of knowing but going ahead anyway. We don't resist that.
Can I ask you this question?
Yes.
You don't disagree that, to go back to the Bank of New England case, you don't disagree that the fact that you need to put 4 employees together to understand the regulatory requirements, because the corporation has compartmentalized their duties, and the court says that's corporate knowledge, and you agree with that?
I agree with that.
So-
Corporate knowledge goes up.
Okay.
And, by the way, also would an agreement or a plan by the corporation to compartmentalize and be willfully blind. You would be able to show one or more people had the willful intent.
But if I understand what the Attorney General is saying is, you have one or more people with, let's say, reckless, they recklessly didn't, they knew that there should have been the Wonder Guard on this thing, and they didn't do anything. They recklessly didn't do anything to make sure that it was on this patient's treatment sheets. And then you have somebody else, totally unconnected, acting. I mean, what's the substantive difference between adding up people to make one corporate knowledge and adding up people to make one reckless action with intent.
If they were saying that there was recklessness in taking these things off the sheets, they don't need anything further. If there's any single individual whose conduct meets the recklessness standard, acting knowing of danger but going forward anyway or omitting to go forward.
Even though that person wasn't on the scene
Certainly.
at the time.
The
That would
causation chain doesn't depend on whether they were there at the time. The time bomb set to go off is just as reckless as the one that you pull the fuse on. So if that's all they wanted, they would have that under the existing law. They're asking you for something more. They're asking you when they say the person over here who had the knowledge didn't believe there was any risk of harm by that, didn't have any reason to think that, and the person over here who has acted didn't have any knowledge at the time they've acted. Now, I see I guess I'm done, but I would like, if I could, say one thing about the second count, just to suggest a disposition. Could I do that or no?
Yes, you can. One sentence.
I would like the court on the second count, rather than reach it on the merits, and the merits are the same, to dispose of it because it is moot, because it does require that you have to intend your conduct and intend the harm. We're the only prosecution ever brought under that. It's been repealed and replaced with a statute that says recklessness is enough. So your decision here will have all of the significance of a railroad stop that you slept through on a train. But I would say in those circumstances that it's appropriate, because they admitted, as they had to below, no one says here that we intended to harm Mrs. McCauley, that it's appropriate, since that requires intent of harm, to dismiss that one as moot. And if you did that, you would be doing what Alexander Bickel said years ago, if it's not out of place to quote a Yale professor, you would be exercising...
Not when the Chief Justice graduated from that law school.
Yes. But you would be exercising what he called the passive virtues and not rushing to meet that issue before you have to, and focus on the manslaughter. Thank you.
Thank you, Mr.
Thank you.
Howarth. Good morning, Mr. Levitz.
Good morning. Why isn't what Mr. Howarth has suggested you can do enough?
Well, from what I understand, Mr. Howarth is now suggesting, and in Life Care's reply brief, and of course he's suggesting it, so Life Care is suggesting it, in its reply brief, that they concede that the basic premise in beneficial finance is this, that no, we don't treat corporations as people. We focus on people first, but then there comes a point where we say it's now okay to impute up what a person has done to the corporation.
The corporation is responsible for the acts of its people.
That's right. That's right.
Including intentional acts done within the scope of their employment.
That's right.
So your allegation here is that one or more of these individuals acted with requisite intent for involuntary manslaughter. You can prove it inferentially. Why isn't that enough? Why do you need anything more than that?
We say that the foundation for any kind of aggregation theory is right in Massachusetts law. It's in beneficial finance. I don't know if that's answering the question, but there will be times where we can't say that a single person committed all of the elements of a crime, but we can say that the group, and not just any group of people that we've assembled together.
A group of persons, but one person not.
Right.
There was no individual person who was reckless.
Or who committed all the elements of a crime.
No, that's just acted recklessly. There's
No person who acted recklessly.
We're not, in this case, we say both, but in a situation where there was no person who acted recklessly, we say that it can still be the case that the group acted recklessly. For example, I know that Mrs. Jones has a serious allergy to a certain medication. My colleague knows that we're giving her that medication. We don't talk, we don't communicate, but we're both acting, and this is what beneficial finance focused on. We are both acting for the benefit of the corporation. We've both been given authority to act by the corporation, and so it's fair and appropriate to impute my conduct, my knowledge up to the corporation, my colleague's knowledge and conduct up to the corporation, and then the corporation, at that point, we're not treating the corporation as a person. We're just saying at that point the corporation is responsible for both those things. The corporation possesses both of them, and together they make a crime. And if Mr. Howarth is correct, that yes, you can impute up these constituent parts of a crime, these things that are less than a crime, but you can't aggregate them, then for what purpose are we imputing them up in the eyes of the criminal law? Beneficial finance is a criminal case, after all.
Yes, but because you get the corporation responsible for what its underlings did. That's why you're imputing it up.
That's right, but what we're saying is that you can impute up something that is less than a crime, a constituent part of a crime, and then after you've imputed all that up, it's all possessed by the same corporation that these people were acting to benefit, and it adds up to a crime.
Do you have any case that has done that? Because it's certainly not beneficial finance.
No, well, in the civil context in Massachusetts, it's been recognized since the 1930s. In federal criminal cases, there have been cases.
That's not Bank of New England, I don't think.
Bank of New England talks about aggregation of knowledge in order to prove.
Of knowledge,
Right.
that's right.
In order to prove an element. So what is it that sounds different about what I'm saying?
I
Because
take it,
intent
Mr. Levs, let me see if I've got you correct. If you accept for a moment that intent can be established by willful blindness,
Right.
And we go back to your hypothetical. There's the nurse who gives the medication who doesn't know that the patient is highly allergic, and there's the person who knows that the patient is highly allergic but doesn't know that the patient has been given the medication.
Right.
You're saying neither one of those individuals could be accused of willful blindness, but if there was a person who both knew that the person was highly allergic and knew that the person was getting it, you would say at minimum willful blindness, even if you don't, right? And you're saying if you send those pieces of knowledge up to the corporation, then when they hit the corporate level, you can combine them all.
That's right.
Okay.
That's right. And just to answer Justice Botsford's question, recklessness, after all, is based in part on knowledge. So it's based on risk. So I could do something in one situation that's not reckless, in another situation it would be. So once you combine the knowledge, then you see, does that give rise to recklessness? But there was a question about whether any case has done that. And I refer to State versus Zeta Chi, the Supreme Court of New Hampshire case, where it's from 1997, and the court is talking about proving the element of recklessness as far as the crime of serving alcohol to a minor. And it discusses collective knowledge, and it cites Bank of New England, and then it applies it to the facts. And it says, in this case, the jury could have found that the defendant acted recklessly because this party at this fraternity, the defendant was a corporate fraternity, had been widely publicized. It was the defendant's vending machine that was selling alcohol. Only fraternity members had keys to the room where the machine was kept. There were guests who nevertheless gained access to the room. Someone was making change for the machine, and the court there said it must have been somebody who was part of the fraternity, because only a member of the fraternity would want to sell alcohol. I don't know if that's necessarily true, but that's what the court said. And there were people waiting in line to use the machine. So what did the court do there? It looked at all these actions and this evidence of knowledge and things that could have only been done by fraternity members. And it said, it identified the person who was making change just as someone. So the implication is we don't even know who that person was, but we know it was a member of the fraternity. You take all these things together, that adds up to recklessness. And it has to add up to recklessness. It can't just add up to negligence. We're not criminalizing negligence.
No, I understand that. But could I?
Sure. Go ahead.
Well, are you're saying since manslaughter isn't a specific intent crime, it's
Right.
recklessness, whereas the other one under Section 38 is a specific intent crime, I think you say, right? Well, you say, and I'm quoting from your brief, the Commonwealth is not espousing a concept that even if jurors did not find it reasonable that some, this is under Section 38, that some one or more individual employees must have actually possessed the requisite intent, they could still find the element of specific intent satisfied.
That's our fallback argument. Our primary argument is that it's not a specific intent crime. The operative word here is willfully in that statute, and this court clarified in Luna, and it's not to say that that was the first case to say it. There were other cases, but it was a definitive statement where this court said, even if in the past we've defined willfully as meaning an intent to cause the harm, the modern definition is it just means an intent to engage in the relevant conduct. So we say that this is just a crime requiring general criminal intent Manslaughter just requires an intent to engage in the underlying conduct, not an intent to cause harm. So really there is no specific intent crime at issue here. The lower court, the Superior Court, found that the second statute, the nursing home statute, was not a specific intent crime. And so the case is proceeding on that basis. And then when the question was reported up, there was just a reference made to knowledge and conduct. There was no question raised about the propriety of the earlier interpretation of the statute. So really, there is no issue of specific intent crimes presented here. So, again, we stand by our fallback argument, but it's really not an issue here. And so it's not, when Life Care is conceding as much as it has, it's conceding that the predicates for imputing up various elements of a crime are found in beneficial finance, and instead it's just focusing on specific intent.
It's focusing on intent. No, I don't think specific, just intent.
Okay, focusing on intent, then it's gone a long way to conceding the use of aggregation. And by the way, intent is one of the things that this court has recognized can be imputed up.
Okay, but one difference is that knowledge can be accrued. How can intent be accrued?
Well, we're saying, and again, we say that that's not the issue here because
Why is that the issue here?
Yeah.
because if you're talking about specific intent, we're saying that
No, I'm referring to the
just
intent
intent.
involved in manslaughter, in involuntary manslaughter.
It's not so much accruing or aggregating intent. It's that an inference of intent can be drawn from the totality of the facts and circumstances, the same way it would be with an individual. So like the Zeta Chi court did, they looked at it, they said, all right, if only fraternity members had keys to the room and people were getting in the room, somebody, and they didn't phrase it this way, they just talked about it all adding up to recklessness, but the same idea is there, that somebody must have intended to, some member of the corporation.
Some person.
Right, some person.
Right, but I mean, there's one thing to say that you win if you show that there was a person who acted with wanton or reckless disregard, but it seems that you're saying you win even if there was no person who acted with wanton or reckless disregard.
That's what he is saying.
We're saying.
No human person.
Okay. We are saying that if after you've imputed up the things that you can impute up, beneficial finance talks about acts, statements, conduct, knowledge, intent, if that adds up to the commission of the crime, satisfies all the elements, then the crime is satisfied.
But pragmatically here, it seems that you think that you prevail if you show that various agents of this entity had knowledge that the failure to have the wander guard on this individual would be extraordinarily dangerous.
And knew that she didn't have it on, I think, is part of that, right?
And you have one individual who's helping out, who at best may have known that she did not, had no knowledge that she was supposed to have it. So
May have known she didn't have it.
may
just
have
didn't
known
know
she didn't
was
have
supposed
it.
to.
And you saying that's enough. You win. Because the fact of the matter is the knowledge of that temporary nurse is imputed to the corporation had knowledge that that was a dangerous practice. You combine those two and you win.
Right.
Does that not debase the currency of involuntary manslaughter?
No, because there's still a very high standard. We're still talking about recklessness. And the fact is, we're talking about recklessness by a group of people acting as an entity. A group of people that should be responsible for providing for the right kind of communication and the right kind of coordination to prevent harms. And that's one of the basic principles underlying the aggregation doctrine where it's been accepted. And I note that we don't know of a single criminal case rejecting aggregation in all its forms. All the cases that we've found, and there aren't many of them, but all of them point in our direction, criminal cases.
If this were a sole proprietorship instead of a corporation, would you be making the same argument?
If it were a sole proprietorship,
Not a corporate entity.
so not a corporate entity, well then are we prosecuting the individual or are we prosecuting the
Yeah, you're prosecuting the
corporation?
individual, the individual owner.
If Well, there's a different set of rules for individuals.
Why can't all this, under this theory of aggregated knowledge, why can't it all be imputed to the individual who owns, the sole proprietor who owns the business?
Because Wolanski and Beneficial Finance say if you're going to prosecute an individual, that person has to have personally committed the crime. You can't impute a crime to an individual supervisor or a business owner. But
Even if it's a complex organization.
right.
Isn't the safety valve here, you're saying this kind of aggregation is necessary to ensure the safety of patients, but, I mean, isn't it true that the very fact that the corporation is indeed liable criminally and civilly for the acts of its employees done in the course of their conduct, also a reason for the corporation to make sure those employees are acting properly?
It should be, and I hate to say it this way, but if that worked perfectly, we wouldn't be here.
So you want to invent a new theory of criminal law to make it work perfectly?
Well,
Is
not
that
a
what
new
you're using? Is that what you're using this for?
We don't see it as a new theory, but also I know
Not a
that
theory that's been widely accepted.
it's been accepted in civil cases here. It's been accepted around the country in any case where it's come up.
So Mr. Howarth is not being honest with the
No,
court,
I think
or actually he's mistaken.
I think he's focusing on a very narrow aspect that makes it easier for him to draw on cases that aren't really saying what we're saying, and don't really fit the crimes, because the crimes, I mean, general intent, just intending to take the
So if this were first-degree murder, you couldn't possibly proceed in this way?
It would be very difficult to imagine a situation like that. Can I just, there's a question about civil versus criminal liability. The fact is, though, that, and this court has recognized this on many different occasions in terms of defining crimes that could also be torts. It's recognized that there are times where it's appropriate for something to be a crime, even if it's not, even if it wouldn't be a tort, because of the purposes behind the criminal law to protect public safety. And that's why when we prosecute a crime, we're vindicating the public. We have a different set of interests than an individual party who might bring a civil suit, and we might proceed differently. We might seek...
But you can prosecute this company for the criminal acts of its employees. That's not a question after their beneficial finance.
But if no individual employee commits a crime, but the group that acts as an entity, that the law, that the state gives the ability to act as an entity, to hold itself out as an entity, to do all these things, hold property, sue and be sued, and then that group commits a crime.
With this intent that no one has.
No, an intent that somebody has.
Who? Who?
Somebody that, some member of the entity that can be inferred by looking at the totality of the circumstances.
You've got these different people who, I mean, just take Justice Gant's example. I mean, who's got the intent in that example?
I'm sorry, in which example?
The one where you've got, well, in this case, you've got somebody who knows about wander guards, but somebody else doesn't know that she should have a wander guard. No, she doesn't have one on. Doesn't know she should. Who's got the intent there?
Okay. Well, here in this specific case, the nurse Edwards, if she's given certain information, and this is just based on what's the grand jury testimony, if she's given certain information that there's a potential danger out there, and she's in a position to do something, it's actually her responsibility to do something about it, and she doesn't, that can be viewed as a decision not to.
And Mr. Howarth doesn't disagree with you.
An intentional omission. And that's, okay, but let's say we have a situation where it's not, we don't necessarily have the testimony that is as clear as we have in this case, but yet you have enough testimony where somebody in the corporation, somebody working for the benefit of the corporation, must have intended the conduct, like in Zeta Psi. Some member of the fraternity must have opened that door and let in those underage people and let them buy beer. Whoever it was, it had to be a member. So we're not saying that this intent exists in that everybody has an innocent intent and yet the corporation has a guilty intent. We're saying it exists in someone.
Mr. Levitz, I think your time is up.
Thank you.
Thank you. Take a short break.